A special guest. Really appreciate her time coming in to discuss some complicated and interesting matters on the Deconstructing Consent podcast. Olayemi Olurin is a public defender in New York City. Thank you for joining us today.
I'm happy to be here. Thank you for having me.
Our pleasure. There's a newsy event that's kind of the window into a conversation, but it doesn't all have to be about the particular case. But Kyle Rittenhouse, I guess, and correct me at any point if I'm using terms incorrectly, because there's like actual legal terms, but they've been having these pretrial hearings. I think the trial is scheduled to start next month, around the 1st, if not on the 1st. And we've been reading about how the judge, I think it's a Judge Schroeder, I have to double check, he made some rulings, because there's arguments before trials happen, right, about what can be allowed and discussed, and apparently, how things can be discussed, and even the language used. There is the quote, the kind of pull quote that got me really thinking about this is the judge was saying he's not going to allow the prosecution to refer to the people who were shot, 2 of them shot and killed and 1 of them injured by Kyle Rittenhouse, to be referred to as victims. He said that was a very loaded term, but he would allow the defense to characterize those same people that were shot by Kyle Rittenhouse, who was the person on trial, of course, various charges, including, I think, first-degree homicide. He would allow them to be called, what do we got here? Arsonists,
looters
and rioters, right? He says, the quote I pulled here, Olayemi, is, "Let the evidence show what the evidence shows," the judge says. "And if the evidence shows that any more than one of these people were engaged in arson, rioting, or looting," again, talking about people that are dead or injured and not on trial, "then I'm not going to tell the defense that they can't call them that." So it seems to me there's a lot of stuff. So one, I know there's a whole discourse out there about whether or not, or when people should be called victims.
Mm-hmm.
And I wonder if you could discuss that. I mean, I think for many folks, maybe in our circles or people that are subscribed here, they're not sympathetic to Kyle Rittenhouse in particular, this particular defendant. But there is a discourse about other folks and in other cases about whether or not to use victims and if it implies guilt and if it's problematic. And I was wondering if you could talk about that. I do want to also get to what the judge is saying he will allow them to be called, which is an interesting thing. But the victim thing, why is that potentially, whether or not you agree with it, why is that a potentially complicated a term to be used? Or is it not? Do you think it's not an issue really?
Let me give you all my thoughts, okay? Because, this is a huge thing right now, and everybody, that's all they're talking about right now on PD Twitter, and it's controversial, right? But it's not that much so to me. Let me tell you what it is. So it's a standard defense motion to ask that they don't refer to the people as victims because it's prejudicial. That's a standard motion that's made. It's almost always denied, right? It's never granted. And I think that's the important point, right? I think people like me, it's like, we're not pointing this out to say, oh, the defense attorney is wrong for asking for it, or that we wouldn't want that for our Black clients or the people that are typically prosecuted. What we're pointing out is that it never happens for them, right? I see there's a lot of pushback from certain PD Twitter and certain people being like, we shouldn't be saying anything negative about this. And it's like, well, if you typically say the system is racist, right? That's what we say. It maintains, protects, upholds white supremacy. This is an example of how the system does that. Pointing it out is not going to prevent the system from doing that. And it's also not going to prevent the system from giving that benefit to your clients, because it never intended on giving that benefit to your client. And that's the point. So as far as whether or not, I think the judge's ultimate decision is, he says, they can't say it in the beginning, maybe the beginning of the trial, I think the opening throughout, and they can argue it in closing, I think is what he says. And so, how I feel about that is they wouldn't do it for Black people, right? The reason it's happening here, it's not to be about this philosophical discussion on defense and defendants' rights. And also, I think it's important to remember there's no constitutional right to not have the people referred to as victims. You know what I mean? I see this conversation like leveling up. I think there's a major difference between critiquing this and when we critique like new criminal laws that come out in the wakes of stuff like that. That's different. You know why? Because there we are expanding the carceral state. We're saying that's something new. This is pointing out how the carceral state already exists to protect and maintain white supremacy. So that's my position on that, right? For me, it's not about whether or not I'm up in arms about, you know, that the judge did it or why he did it or who said it or any of the rationale. It's more so, here is a clear indicator of how the system treats white supremacy versus how a benefit it would never give to my clients. And let me point it out to people who otherwise don't know that, don't see that, people that don't see the examples of how the system is unjust. So that's why I say something.
That's really, really interesting context, because I could see that being a Trojan horse for those without the context to come into the conversation only in the philosophical side. And it's not that that's not an interesting debate or whatever, but to discuss things in a dehistoricized way really does no justice to the actual people involved in it now. So while, if I understood you correctly, while there may be some interesting theoretical debate to happen about, you know, this term being used ever or not, in praxis, it's important to realize that this is not something usually granted to the majority of people that are brought in into the criminal justice system, majority of whom are people of color, you know, Black, poor, other marginalized groups. So I think that's a really interesting intervention into that. Yeah. Okay. No, I liked it a lot. That's super interesting. You know, and it just reminds me, not that we don't have to go into it, but the fact that he's out free during the trial, I think is notable as well. Again, not because that's something I don't want defendants to have access to, but because so many people don't have access to white supremacist and reactionary fundraising efforts to keep them out, you know.
A lot of people, let's keep it G real, right? Most of my clients wouldn't have even gotten bail, like of any kind. Like they wouldn't have got the number. They would have been remanded, right? And I think that's what's important. Like these options and this access and these opportunities are given to navigate the system far more flexible than any of the people that the system typically prosecutes. And even in, you're willing to entertain the idea that a victim is too prejudicial for them, but what about how we're prejudicing, you know what I mean, the victims in this case by calling them that? So it's just like, to me, it's not about my personal feelings on whether or not I'd like this world for my clients. My thing is, I would like this world for my clients. I recognize that the criminal system that we have is not going to provide that to my clients. And I'm trying to illustrate to you why this system doesn't do that. It's not because I'm saying, hey, I'm against this. You know, I don't want these rights for defendants. It's not about being carceral. It's about showing you that these rights for defendants, the people I represent, are not afforded in this current system.
Well, that's well put. I think that makes a lot of sense. Well, yeah, again, it's clear whether or not someone would agree. I think it's really well argued and put it clearly. So let's go to, I think it might be, for me as a layperson in this regard, it might be one thing for me to even ignore the reality of this carceral system doing what it is, among other things, created to do, I believe, which is to have disparities in the way it treats people based on race and class and probably gender and stuff like that, and saying, well, in this case, we're gonna do the rare move of really restricting the use of the word victim in a homicide case. Okay, that would be one thing if I was to be naive enough to say, well, okay, you know, he's just trying. The judge is just trying to be pure here. But he went on to go and say, well, I am certainly not going to rule out other words to characterize and describe these people that he won't be allowed to be called victims. He said, let the evidence, show what it shows. How did that strike you, Olayemi, to talk about evidence being brought forth in a case about people that weren't on trial to determine what we call them, and especially using criminal language, like arson is a crime, looting is a crime.
Right, that they were not tried and convicted of, right? But here we are, we put them on trial for it. And if you've sufficiently, besmirched their good name by the end of the trial, you can argue it in closing. Let me be honest with you, it does not surprise me. Nothing ever that I express, I express outrage for the benefit of everybody else. You know what I mean? I'm just like, I just want you to see what I'm seeing so you know why I feel this way. But I am never surprised. That's what I expect. I'm just like, let me get to the nonsense first so I can tell you all about it. But it does not shock me. That's what I anticipate. That's how they've handled. Listen, Kyle Rittenhouse walked past the people and got a bottle of water after he just like, I was just watching the body cam footage the other day of how the police interacted with the men who killed Ahmaud Arbery, and they're like talking to Tim like, oh, what a rough day you must have had. Oh, don't trouble yourself to get your ID now. Oh, don't get no blood on your pants. That's how they're dealing with them. So no, it does not surprise me. That is how the system operates. That's why I always say the criminal system is not insidious. It does not do anything like in the shadows. That's not it. Does it loud for a court reporter to hear, but everybody that's paying attention. It's just that people aren't hearing that, and so often when you do see, things like this is treated like it's a mistake, like it was a bad call, like it was a one-time thing, because you're not seeing the judge do this nonsense all day, every day, but anybody that's there knows that this is how it goes down. So it didn't surprise me. Honestly, I wouldn't be shocked if worse had been said, right? It didn't shock me. I'm just like, I just want to illustrate to people, look, you know what I mean? Just look. When is the judge ever primarily concerned about what's too prejudicial for the client? They talk to clients like they're guilty at arraignments. Judges will lean over to you and let you know, hey, you might want to take that plea because he get in front of such and such, so it's nonsense.
Wow.
Nonsense.
Wow. I was reading earlier today, an article from, what is this? Wisconsin Public Radio. So I don't know if the reporter is with like the national NPR or they're a local reporter or what have you, but I was reading a bit about some of the other things that I guess that were being discussed and negotiated at pre-trial hearings. And some of this really, either I'm confused or it's weird, and I wanted to kind of get your impressions on it. And if you have nothing to say about it, it's okay. So I guess the defense was worried that bringing expert witnesses about use of force, like the defense bringing one and the prosecution bringing another one, would quote unquote confuse their jury, which I thought was. I'm sorry, the prosecutor was worried about it. I'm sorry, the prosecutor was worried about about bringing multiple, witnesses talking about use of force, because of course the defense is trying to, among other things, they've been giving us the impression that they're gonna use like a self-defense argument here. And the prosecution was saying, oh, I don't know if we should do that. So then the defense, I guess the judge ruled that the defense is going to be allowed to bring this guy Black, John Black, as an expert witness. And then the prosecution said, oh, well, if it's limited in scope, what they discuss, we won't bring our own witness. We agreed to do that. And I don't know if I'm understanding this right, but the prosecution not bringing their own witness specifically like to confuse a jury in their favor, not to contradict an expert witness that the judge has said they're going to allow to testify on an important issue like use of force. That struck me as weird. Am I missing something, or is it?
I don't know all the details, but I would imagine. I mean, typically, prosecution, defense, there are multiple expert witnesses, right? Everybody brings the expert. I think what might be happening here is the defense is raising self-defense, right? So self-defense is an affirmative defense, meaning typically in a case, the prosecution has a burden. They have to prove their case beyond a reasonable doubt, and the defense doesn't have an obligation to have a case at all. They don't actually have to do anything. But if they raise an affirmative defense like self-defense, they do have a burden. So now they have to prove that by clear and convincing evidence. So I'm imagining, based on what I'm hearing, that they're probably offering an expert witness as to their self-defense case. And so the prosecution is like, well, that's their case. The prosecution would have already made their case, rested their case. And maybe they're saying here, if he's limited to just whatever you're talking about with your little self-defense thing, then it's cool. Like that's what I think I'm hearing.
I see. Okay. No, that would make a lot more sense. I wasn't familiar with the concept of an affirmative thing, which I guess puts more burden on the defense. Very interesting. Okay. Have you ever worked? I'll close it up with a couple closing questions I was thinking about, but before that, it just occurred to me. And have you ever worked in any case that in some way did or could have involved like a self-defense defense?
Making a self-defense case. Right now, I'm trying to think. No, give me a second off the top of the dome.
Sure.
I mean, here's my thing, right? So self-defense, I mean, do people say self-defense to you? Yeah. So like, have I gone to trial and raised the affirmative defense of self-defense? No. But like, it doesn't get there. But yeah, there have been lots of times it is said there, but as far as trial, I haven't gone to trial on a self-defense. Yeah, I haven't experienced that yet. I'm sure it'll happen though.
Just curious. A lot of the at least the national stories that have gotten attention in, I don't know, the last decade or so that I can think of, a lot of times they have the specter of self-defense. The cases that get that attention are almost always like people killing Black people or leftists.
And that's the thing. So I really hate self-defense. Like, I'll spare you my holds, because it's not it's counterintuitive, right? When we think of what it is legally, when we think of self-defense, like, I defended myself. For whatever reason, I'm in a situation where I defended myself. Self-defense under the law is like, did you use proportionate violence to what you thought was the imminent threat? It just isn't logical. Like, I'll give you an example. When I was clerking for a judge, there was a case that we're reviewing where the kid had been like convicted for like whatever, like threatening them or something. They convicted him. He raised self-defense, but it was like these kids had been beating him up. Like, they beat him up all day. Like, they beat him up every day. They followed him home, and they were like waiting out his house to like beat him violently. So he went inside into his house. He got a gun and he came back outside. And I can't remember if he actually shot or anything like that. I really don't recall the rest, but I do know they're like, that's not self-defense because he was already safe. Wow. They were like, he's already inside. I'm like, I think you misunderstand the concept of how stuff goes down in the real world. Like, they're a continuous threat to him. Like, he can't stay home forever. This idea that like there's no context that matters. The fact that they were a threat to him before, they'll be a threat to him tomorrow. So I just don't like self-defense because it never makes any logical sense in terms of what our dynamics are until all of a sudden there's a white supremacist in the news. Now all of a sudden everybody's like, oh, stand your ground. Like, so.
Well, exactly. Yeah, no, that's really interesting, and thanks for giving that type of background and your take on it, because that's sort of what, again, as a layperson, I was thinking. I feel that so much of that would depend on when you start the clock, really. Like, so what occurs to me, again, just as very much nothing approaching a legal mind or expert, I think it's very interesting. The idea is very interesting to me, to put it benignly, that someone like Kyle Rittenhouse could leave my state here in Illinois and get a gun illegally, break curfew, travel across another state towards a situation that he, by all accounts, knew was dangerous and rough and was going there, with the intention to confront it, and then claim that people were assaulting him or he was in danger. It's like, if you start the clock like now, fine. If you start the clock like this dude planning out to go, equip himself to be able to shoot at people in another state and traveling there illegally, then it seems like a very tenuous strength to the claim.
That's all the law is on it. Like, when you're in law school and you're reading it, it's just a bunch of judges, regular people. That's the thing about the law. It's regular people, codifying what they think, and it's just making little semantic differences depending on how you want the case to go. So, listen, I know that there's this popular idea that in order to be an abolitionist or a leftist and really progressive and believe all these different things, that means that I'm supposed to be. Listen, I don't have no time to defend no white supremacists. I am not under the impression, when I say the criminal system, I work in the criminal system because I want to make a better world for Black people and people of color and poor people that are marginalized by this criminal system. That does not extend to white supremacists. I don't got the time. I think that he deserves all his constitutional rights to be protected. I believe that he is entitled to a zealous defense, and he's not going to get one from me. Not in the court or out it. You know what I mean? He's got that. He's got his lawyers. He got them. If you're talking to me, you ask me, you know what he did? We know what's up. Ain't nothing about it. There's no self-defense. Now his lawyer is entitled to and encouraged to argue that in court. Like, argue, go ahead, do your thing, boo. But we know what's up. We know what's up. Like, so that's that on that. But yes, that's what they're going to do. They're going to get in court and be like, listen, don't start it from there. They're going to be like, he was there for some other reason. He wanted to observe the festivities. He thought, yes, they're going to, listen, the judge was arguing, not the judge, his lawyer was arguing last week that that the gun isn't illegal or whatever because it might have been hunting season or a permit or a rifle permit. He didn't have child, all kind of, listen, and you got to do what you got to do. I get that as a defense attorney, do what you have to do. But I also think there's something to, I think you have to make whatever arguments for whoever you want and represent one, this is the next thing. But I think there's a difference between being a public defender and, you represent everybody or poor people of that and like going out of your way to like represent white supremacists. You can do that. I'm not going to light you up about it because I don't care about it, but I'm not going to help you. I'm not going to be on there. Like, I just feel like there are a whole lot of people I could be like, well, the rights of, and I'm not going to do it for Kyle Rittenhouse. I'm not going to do it. So that's where I'm at.
Well, I think that it's still there's a philosophical consistency in what you're explaining, and some attorneys certainly it seems like a lot of times the only philosophical consistency they're interested in is like the professional interest or being collegial and things of that nature. Whereas at least you're really clear. You're not saying he shouldn't have a right to representation. You're just saying I believe in these constitutional rights for everybody at any point, no matter what they're charged of, no matter where they are. I just as myself as an individual, I'm not interested in taking on those cases myself. There's no real conflict there, it would seem to me. Also, it would this is in a different direction than what you were meaning, but this is a client with literally, I'm not making this up because they put up his bail. He has millions of dollars of resources at his disposal, which is a very different situation than being a public defender and taking taking someone that comes in. Even if it was your public defender and like a white supremacist did come across a poor person, that's still a different thing than someone $1 million client. It just is a different thing.
Very different. This were when he got bail, right? I'm not criticizing the act of him being able to get bail, right?
Sure, of course.
Whatever, right? I'm not criticizing that. Now I will point out the fact that he was able to get bail, and but I don't have a problem with that because a world in which bail laws that will harm my clients, right? Like a world where people increase these kinds of restraints that's harmful to my clients and the people that I represent and Black and brown people, right? So that's why I wouldn't. But in the case of what is the current controversy, we don't get that. That's already a benefit that doesn't exist. The things that are happening, Kyle Rittenhouse is not being like railroaded in any way. His rights are not being endangered. Nothing that we say to criticize Kyle Rittenhouse is going to negatively impact us any more than the system already is doing that. So that to me, in there. And I think sometimes for me, I tell people all the time, I became a public defender. I do this job because it's important to me that the only Black person in the courtroom not be the defendant, right? It's important to me that I help my community. I didn't think it was good enough for me to be in this profession where there's like less than 5% of us are Black and don't do anything that like actively helps Black people. That's why I do the job, right? So that being said, like, it's not about this like deep ideological commitment to like whatever you think is like the defense attorneys are arguing as a group right now or whatever, right? I'm not, a white supremacist is not who I'm in the business of helping. I didn't join the game for that. Now, if you join the game for, overzealous defense, yada, 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 everybody, and that's you, do you. I support it, I endorse it, but not me. Like, I'm not here for the cows. Now, if where his rights converge with my clients, you know what I mean? If his rights were being railroaded, if the court was saying, he's to start trial tomorrow, even though they didn't have time to prep, I'd be like, oh, that's not right. Well, and when I say it, I'd be like, oh, that's not right. I mean, privately, I would be like, oh, that's not right. But I would not on Twitter like, oh, that's not right. Poor Kyle. No, I'm not doing that. There are enough people getting railroaded in the system for me to use as an example. I don't need to defend Kyle. And that's how I feel about it. Everybody and their mama could be mad about it, but that's where I'm at.
One last question of something I read, if you don't mind. I'm quoting here. Let's see. Schroeder also said he's likely to allow video from a witness. I think this is something that the defense was asking for. Allow video from a witness showing officers thanking armed civilians and giving Rittenhouse and others water before the shootings, like the stuff we were talking about that we've all seen. The defense says this speaks to Rittenhouse's state of mind. Binger, who's a prosecutor, argued against it, saying law enforcement shouldn't be on trial. I think that's a really fascinating little thing here.
No, that is, yeah. That's
right. I think that's super, super interesting.
That's interesting because I would think that video to me, that video does not, you know what I mean? Like, I guess I respect the thought process because I immediately said the video and I'm like, why on God's earth would you want that in there? And I'm like, oh, that's your argument.
Like maybe these officers were encouraging in a young, impressionable kid that he was doing the right thing by being there. I could kind of see why the defense would say that. And then I think it's super telling that the prosecution, who we hope is going to pursue justice in this case, kind of shows their hand. It's like, actually, we're people that work with police officers every day. So ultimately, we don't want to make police officers look bad here.
Yeah, right. Which don't get me started. I'm gonna leave that be. But I don't know. I guess I'm thinking about it. I'm like, speaking to his state of mind. I don't think it does. I also don't think it's like so. Oh, like. What, did they rule on this? Did they make the
call? The judge said he's, according to the article from the Wisconsin Public Radio, Schroeder said he's also likely to allow the video from a witness. This is from the 25th, so 2 days ago. It might be outdated. So I think that's interesting. Yeah, they're taking a big swing. They got something up their sleeve if they think that's going to help them. It seems it's very interesting.
Listen, they're just relying. Let's keep it G real. They're just relying on getting some racists on the jury. That's what it is. So like, listen.
Yeah.
The reason why I talk about the presumption of innocence all the time because it doesn't exist, right? Like that's why there should be all these things I talk about is not because I'm trying to illustrate how the system should be acting like I'm trying to tell you it doesn't. That's not real. In this case of Kyle Rittenhouse, what this is going to come down to is who wants to make it make sense. You know what I mean? Who wants to let him off right? That's what it is. That's why picking a jury is so important. If they get a couple of racists on the jury, they'll be good. Like that's the truth. But as far as it making any real sense.
Right. No, that's interesting. Yeah, right. And this could be related because I was just thinking as you were leading into that, like depending on who they feel the jury will be, they might feel like their feelings towards law enforcement might be positive enough that showing their client the positive interactions with law enforcement will just reflect well on him generally, maybe.
You know? Exactly, because I have friends. I know people. I know people. I have to be clear. I know people who would feel that way, right? Yeah. Who are like, oh, the police, and we do need, police, the friends, community, water. I know people who would feel that way, and then I know a person like me would see that video and immediately fly into a rage. like you show me that video if I were in a different world where I was someone who's gonna be dirty, which I would never be. So before anybody be like, oh, it's so personal. But that would anger me, me so. Too. It could go, if they have the right demographics, which they likely may, they could get that off. I could see it. That's an argument to be made. And I guess ultimately, it'll be on them. They could whether or not they show it, what they decide to do. But I just don't think it speaks to the state of mind. I don't really get that. Like, why? What is being cordial with the cops? Then mean like. What's that got to do with just your state of mind when you defend itself? Like, even if think about it, even if I conceded to your idea, right? Okay, he didn't kill them. He didn't intentionally go murder them. This is self-defense. What I don't understand. How is that impacted at all based on this interaction where he's getting over? It doesn't mean it. Like, it means nothing because if I'm going with your theory, right? He didn't plan any of this. All of this is an isolated, just happened, quick in a moment or whatever. He was in this interaction. He kills them, whatever, because defense. Then it still has nothing to do with what his state of mind would have been, whether one way or the next, right? Because it's just this little moment where he reacted to these aggressors, if that's the story I'm to believe. So it still doesn't serve that purpose. But child, what do I know? Let them do them.
Thanks. Last question. It's less. I think it's probably less of a legal question than just like I don't know, a philosophical one. So you can or you can't address it, whatever you want. But it occurs to me like, okay, everyone. It's not under debate whether or not he shot and killed these people and shot and injured another person. It's the court is going to have to determine whether or not it was a crime to do so. What if in these types of situations, a person who is charged with killing leftists or killing black people, if they and they admit that they killed them, but they're saying it wasn't murder, right? It was a self-defense, whatever. When they get acquitted, what is the, again, not a legal question, but when they get acquitted, what is the implication of guilt of dead black folks for just existing or living or protesting. Is there an implication there in society of their guilt when we say white folks who killed them are innocent?
I think it's consistent. I think it's consistent with the regular narrative, right? Black people are always put on trial for even when we're the victims of a crime, right? Anytime, every single time we get a national attention on a police brutality case, what happens? We have to spend the next year fighting this dead person's character while he uses all kinds of things that have nothing to do with that moment in front of us, you know what I mean, to justify, which is interesting, right? How when a Black person is killed by the police, all of a sudden their entire backstory matters. But when this white guy goes to this Black Lives Matter protest and kills these leftists, all of a sudden it doesn't matter. Anything that happened outside of this incident, him planning to go there, him traveling across state lines, it's only supposed to be this incident right before us. But I would say it's consistent, right? America it criminalized Black people. It criminalizes us in life. It criminalizes us in death, right? And I think there's a reason why Black Lives Matter, as not just like an organization, but as a slogan, has been able to, take away the way it has, because that's pretty much what it is. They tell us consistently, our lives don't matter. It's not as significant, right? Yeah, okay, they killed you, but it's justified, or it's fine, it's okay. It's wrong enough that we could give you a settlement, but not wrong enough that we could charge these officers, not wrong enough that we could fire them, not wrong enough that we could change the system or the practices that keep killing you. So I think it's consistent. They tell us, we don't care about you. And more importantly, not more importantly than just we don't care about you, but we will protect the people that actively harm you. So that's what it tells me.
That's why people in the system willing to fight these fights legally, like yourself, are so important. We'll let you go now, Olayemi Olurin. A really courageous voice and a great mind. Really appreciate your time on here with us.
Thank you, E.